Good afternoon, Your Honor.
Good afternoon. Mr. Lowe, come on up, sir. This is cause number CR 22-67, State versus Robert Gerard. We're set today just for another status hearing regarding Mr. Gerard and his hospitalization. With good news, the court has received information that Mr. Gerard was transferred to Vernon State Hospital on May 2nd. So he waited, looks like Ms. Abraham says, 449 days. So, which is quicker than we thought he was going to get there, despite how long that was. So I'm glad that Mr. Gerard had an opportunity to get into a bed. So hopefully we can just reset this case and kind of do a status of him every now and then hopefully we'll get some good information from the state hospital and get him back here and resolve this case. So do you have any other information on Mr. Gerard at all?
Your Honor, I suspect you'll know before I will what his release is, and so he will ultimately wind up, I understand, in Terrell Court, and he has to have extensive treatment. So I just wait and see what happens. So I don't know what to suggest in the court, maybe 3 months or so.
Yeah, I was thinking maybe September, and then we can just ask Ms. Abraham to email Vernon State, see if we can get an update prior to the court date, maybe late September. I was thinking maybe like September 24th. Do you have your calendar with you?
I do, Your Honor.
Check that. Let's make sure that we're not double booking you.
Your Honor, it's not on my calendar, but I have a jury trial in September, but I don't know the date. Can I get back to you? This one, we could just wait and get a date. Yeah, because that should be fine.
What about October? What about like October 1st or 3rd?
Yeah, whatever. My calendar's clear in October so far.
All right, well, let's do that. Let's set Mr. Gerard for status hearing on Tuesday, October 1st.
All right, Your Honor.
All right, thank you, Mr. Lowe. Appreciate you.
Yes, sir.
Okay, Your Honor, on Alejandro Valencia Ezekiel.
Yeah.
Um,
Hang on, let me get to that. Where's that at? Can you say the name? Can you say the name one more time?
Alejandro Valencia Ezekiel.
No, see, I think it's Ezekiel Alejandro Valencia, but that's okay. I get where you're going now. On Mr. Manning, yes, go ahead.
Okay, the jail overlooked him being on the list, and he is currently being housed in Hopkins County, so we will need to reset him.
Housed in Hopkins. Do we know if Hopkins has Zoom ability at all?
Not sure.
Not sure. Okay, Mr. Manning, do you want me to see if I can get Mr. Valencia on Zoom today? Do you want me to see if we can call Hopkins and see if they have that ability? If so, we can do that, or we can just reset and.
Yeah, it's just arraignment. So I think either way, I'll need more time to obviously get the discovery, go over that with my client. With him being in Hopkins County, it's a little more challenging. So if the court wants to go through the effort of getting him arraigned, I'm fine with that. But otherwise, I'm also fine with just kicking it out.
All right, let's reset for arraignment. Do we know, Ms. Abraham, what he's being held in Hopkins on? What kind of charge?
No, he's just being housed.
Oh, just being housed. I'm sorry.
Yes, sir.
Okay, so we can, Mr. Manning, you want us to bring him back on June 13th?
That'd be fine, Judge. That should give me plenty of time to get the discovery, and hopefully he'll get cycled back through here.
All right, and Ms. Abraham, if you could just make a note with jail staff to have him back in our county on June 13th, at least for that hearing.
Okay, we will.
All right, Mr. Manning, who are you ready on now?
The judge ready on Mr. Michael Edward Davis.
All right, court calls cause number CR 22-176, CR 23-124 and 125, and CR 23-149, State versus Michael Edward Davis. And is this a plea today, Mr. Manning?
Yes, Judge, we're proceeding on CR 22-176 with a plea of guilty, and the remainder of the cases that are listed in that case, in the plea terms of that case will be rejected or dismissed.
Okay. I think I've got all of the paperwork here. All right, Mr. Davis, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Michael Edward Davis, is that correct?
Yes, sir.
And Mr. Davis, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And Mr. Davis, have you ever been diagnosed with any type of mental condition?
No.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's work as your attorney?
Yes, sir.
Do you feel like you've had enough time to discuss all of your cases with him, have all of your legal questions answered, and that you understand everything that you've read and signed in your plea agreement?
Yes, sir.
Mr. Manning, do you believe Mr. Davis to be competent?
I do.
You've explained to him his rights,
I have.
and do you believe he's entering into this plea agreement intentionally, knowingly, and voluntarily?
I do, Judge. We've discussed this case and his other cases. We discussed possible defenses as well as the state's evidence against him. And I believe that he's weighed those and is entering into this plea intentionally, knowingly, and voluntarily.
All right, and let's see, before I go forward, I see that there's an enhancement paragraph. Is that true from the state? Is that in the indictment or is that in a Brooks notice?
Your Honor, I believe it's in the indictment. I can make sure of that real quick.
If you wouldn't mind, do me a favor. If you'll go ahead, I'll turn on the sharing capabilities in just a moment. Ask that you share that to the screen so that we can view that.
Yes, sir.
All right, let's see here, Mr. Davis. I see that you are charged by indictment with a second-degree felony of fraudulent use or possession of identifying information, number of items between 10, but less than from 10 to less than 50. I see the plea agreement in your case. The recommendation from the state is that upon your plea of guilty, the state is agreeing to abandon count 2 of the indictment. I'm assuming that that's an enhancement paragraph rather than a count, but that their recommendation is that the court review the evidence and then convict you of the offense, assess your punishment at 20 years confinement in the Texas Department of Criminal Justice, and the state is dismissing several cases, including indicted cases, CR 23-149, which is a manufactured delivery of a controlled substance, CR 23-124, evading arrest or detention with a vehicle, CR 23-125, evading arrest or detention with a vehicle, unfiled DA number DA 2022-49, forgery of a financial instrument, DA 2022-47, theft of property between $2,500 less than $30,000, and DA 2023-276, evading arrest or detention with a vehicle, and finally DA 2022-50, failure to ID fugitive. In addition to that sentence, you would have court costs of $290, reimbursement fees of $105, and you would receive 556 days credit toward your sentence for the time that you've spent in jail in this case already. So, Mr. Davis, is that your understanding of the plea agreement?
Yes, Your Honor.
All right, yours as well, Mr. Manning.
It is, Judge.
All right, then, Mr. Davis, how do you plead to fraudulent use or possession of identifying information with the number of items being 10 or greater, but less than 50?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of that crime and for no other reason?
Yes, sir.
And Mr. Davis, has anybody threatened or forced or pressured you to plead guilty to this crime?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence supporting the plea?
No objection to states one.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
All right, Mr. Hartwell, do you have that indictment that you can?
I do, Your Honor. Let's see if I can.
All right. And Mr. Hartwell, let's see. There you go. That looks good. Okay. And so state, just so I'm clear, so in the plea agreement where it says state agrees to abandon count 2, there's no counts in this indictment, but I do see an enhancement paragraph 2. Is that to what you're referring?
Yes, Your Honor, and my apologies, getting the enhancements mixed up with the count.
Okay. I think it would be, since this is going to be a judgment that's received by TDC, I think it would be best if we correct the judgment to say state agrees to abandon paragraph 2 of the enhancement paragraph 2 of the indictment.
Yes, Your Honor, and we can get a corrected front page to the court.
Great, thank you. All right, so Mr. Davis, I have to ask you at this time, you see this indictment on your screen, correct?
Yes, sir.
How do you plead to enhancement paragraph 1? Is enhancement paragraph 1 true or not true?
It's true.
And has anybody threatened, forced, or pressured you to plead true?
No, sir.
All right, the court will accept the defendant's plea of true to enhancement paragraph 1. All right, thank you, Mr. Hartwell. You can stop your share screen if you want.
Yes, sir.
All right, I don't believe I have the stipulation of evidence. Mr. Manning, can you put that in front of the screen or summarize it, whatever is best for you? A little closer for me. All right, thank you, sir. All right, based on the court's review of the evidence, stipulation of evidence, the court finds that there is sufficient evidence to convict Mr. Davis of this offense. The court will follow the plea agreement and recommendation of the state. Court hereby convicts Michael Edward Davis of the second-degree felony offense of fraudulent use or possession of identifying information. The court finds that the number of items used or possessed was 10 or more, but less than 50. The court hereby finds that the state has abandoned enhancement paragraph 2 of the indictment. Court finds that the recommendation of 20 years in the Texas Department of Criminal Justice is appropriate. The court does assess punishment at 20 years confinement in TDCJ. The court also orders Mr. Davis to pay court costs of $290 and reimbursement fees of $105. And the court awards Mr. Davis 556 days credit towards his sentence for the time that he has already spent in jail on this case. And the court does dismiss under section 1245 all cases identified in the terms of the plea agreement. All right, Mr. Davis, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Good luck to you, sir.
Thank you.
You're welcome. Mr. Schmidt, what do we owe this special privilege and honor?
Well, I love it here, so I wanted to do some pleas for the court today.
Oh, I thought maybe you were frightened in your office thunderstorm and wanted to come over and seek the shelter of good company.
This place is coming down tornado, so I'd rather be in my office.
That's probably true.
Yeah.
All right, you say Mr. Germany?
Yeah, he's ready.
Tyler Young, Germany, CR 18203. All right, Mr. Germany, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you, sir. You can lower your hand. Your name is Tyler Young, Germany. Is that correct?
Yes, Your Honor.
And Mr. Germany, are you a United States citizen who reads, writes, and speaks English?
I am.
All right. And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's representation?
Yes, I am, Your Honor.
Do you feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, I do.
Is there anything about the plea agreement you reached with the state and the paperwork that you signed that you do not understand?
No.
Mr. Schmidt, do you believe Mr. Germany to be competent today to enter into this plea agreement?
I do.
And do you believe he's doing so intentionally, knowingly, and voluntarily?
Yes.
Does your client waive the formal reading of the state's motion to adjudicate?
We do.
And is your client pleading true to all counts alleged?
Yes, sir.
Okay, let's see. I don't have that motion, so let me just 1 second. Let me go pull it up. All right, Mr. Schmidt, can you see that?
Yes, sir.
Okay. All right, so Mr. Germany, it appears that you were in this court on November 8th, 2018. You pled guilty to the state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. The court heard the evidence and followed the plea agreement that you reached with the state. The court deferred a finding of guilt, did not convict you on that date, however, placed you on 4 years of community supervision. During your period of community supervision, your community supervision was then extended for an additional 2 years. Court also assessed a $1,000 fine. It was during your period of community supervision that the state filed its motion to adjudicate in July of 2022. And within that motion, as I'm displaying to you, you can see that the state has alleged what appears to be 6 separate counts of violations. Mr. Germany, I would ask you at this time, of those 6 counts, are all 6 counts true or not true?
True, Your Honor.
And you're telling me that the counts alleged are true because in fact they are true. You're not just saying that they're true in order to reach a plea agreement, right?
That's right.
All right. And Mr. Germany, has anybody threatened, forced, or pressured you to plead true to any of these counts today?
No.
All right, then court does accept Mr. Germany's pleas of true. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of truth?
No objection.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
All right, then based on the evidence before the court finds that and has accepted Mr. Germany's pleas of true, finds that on the basis of that finding that Mr. Germany has violated the terms and conditions of his community supervision. The court this day follows the plea agreement reached between him and the state of Texas, and at their recommendation, the court hereby convicts Tyler Young Germany of possession of a controlled substance, penalty group 1, less than 1 gram, a state jail felony. The court hereby adjudicates guilt, revokes his community supervision, assesses his punishment at 12 months confinement in the Texas Department of Criminal Justice State Jail Division. Court orders him to pay the previously imposed financial obligations, including fines, court costs, restitution, and the court awards Mr. Germany 137 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Germany, whenever you do get out of the state jail, if you've not discharged all of your fines, restitution, and court costs, you're ordered to report to the Van Zandt County Courthouse, to the Van Zandt County District Clerk, and speak with them about discharging those financial obligations. And if you can't do so on that day, then to enter into a payment agreement in which to pay those out. Failure to do so will result in the court issuing a warrant for your arrest. Do you understand?
Yes, Your Honor.
All right, Mr. Germany, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted. Good luck to you. All right, Mr. Schmidt, are you ready on your next client? Is that Daniel West or Zachary?
Yes, sir.
Daniel West?
Yeah.
Daniel Keith West, CR 2381. All right, Mr. West, we still going forward with the plea today, Mr. Schmidt?
Yes, sir.
All right, Mr. West, if you'll raise your right hand, I'm going to place you under oath. Your name is Daniel Keith West, correct?
Yes, sir.
All right, Mr. West, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. All right, I don't have the motion in this one either. Give me a second. Let me pull that up.
Oh, you want that?
All right, Mr. West, you appeared before this court on January 25th of 2023. You pled guilty to burglary of a habitation, a second-degree felony. The court heard the evidence in your case. The court then followed the recommendation of the state and your plea agreement. The court assessed your punishment at 5 years confinement in prison. The court suspended that and placed you on community supervision for 5 years. And it was during your period of community supervision that the state filed this motion to revoke on February 27th of this year, 2024. In their motion, they have alleged what appears to be 7 separate counts of violations. Mr. Schmidt, does your client waive the formal reading of the state's motion to revoke?
Yes, sir.
All right, does he intend to plead true to all 7 counts?
Yes, sir.
All right, Mr. West, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the legal work he's done for you?
Yes, sir.
Do you understand everything that you've read and signed that's part of your plea agreement?
Yes, sir.
And do you have any questions before we go forward?
Yes, sir.
All right. All right, Mr. West, I'm going to ask you at this time, how do you plead to those 7 counts alleged in the state's motion? Are those counts true or not true?
True.
And you're telling me that each one of those counts is true because in fact, what is alleged in those counts is in fact true. You're not just saying that to get a plea agreement, correct?
Correct.
All right. Court will accept Mr. West's pleas of true. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
All right, that's admitted into evidence. The court does take judicial notice of the defendant's judicial confession. Mr. Schmidt, I didn't ask you. I know that you would have stopped me had you had any concern regarding the defendant's competency, but I'll ask you at this time. You do believe that Mr. West is competent and that he is entering into this plea intentionally, knowingly, and voluntarily?
I do, Judge. It's my understanding that Mr. West has been previously diagnosed with mental illness. He's currently receiving medication. I've talked to him about those issues. I believe him to be competent. I also believe that he knows fully what's going on and the consequences of his plea.
Thank you, Mr. Schmidt. All right, then, Mr. West, based on your judicial confession to the allegations, the court's going to find each one of those to be true. And based on that, the court's going to find that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement that you've reached with the state. The court hereby revokes your community supervision, assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice, orders you to pay the balance of your financial obligations, including court costs and restitution. And the court awards you 292 days credit towards the sentence for the time that you've already spent in jail on this case. Mr. West, whenever you do get out of prison, if you've not already discharged your court costs and your restitution, I need you to report to the courthouse to pay those at once. And if you can't afford those in full, you can work out a payment plan and the county will work with you. If you don't do those things and you leave your court costs and restitution owing, then the court is likely to issue a warrant for your arrest. And one of the reasons I bring this up is because I had a hearing the other day with another gentleman who told me that once he got out of prison, his parole officer told him, hey, you're good, you're done. You don't need to do anything else. But the problem is that parole officers, they don't collect on fines, court costs that are owed to the county. So your parole officer, when you get done, if you get out on parole before your sentence is extinguished and they tell you, hey, you have no more obligations, just know that they don't collect for the county. So these things will still be out there, even though your parole officer or someone else tells you at the state level that you have no more obligations, okay?
Yes, sir.
All right, Mr. West, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Go like this, sir.
Back.
All right, is this Mr. Wooten?
Yes, sir.
All right, this is cause numbers CR 22-55 and 56, State of Texas versus Zachary Taylor Wooten. Mr. Wooten, sir, if you'll raise your right hand, I'm gonna place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go lower your hand. Just make sure you speak up loudly and clearly for me. Let's see. Have your motion. Yeah, I don't have these motions either. Give me just one second. Mr. Schmidt, can you see those?
Yes, sir. Your head's in the way of one of them. It's kind of cool.
Let me
You're
duck.
floating.
How about now?
That'll work. That'll work.
Give me just a second. I did that just for you. Better?
Yes, sir.
All right, Mr. Wooten. In cause number CR 2255, you appeared before the court last on September 20th, 2022. You pled guilty to assault of a family or household member by impeding breath or circulation, a third-degree felony. The court heard the evidence. The court followed your plea agreement and the recommendation from the state. The court deferred a finding of guilt and placed you on probation or community supervision for 2 years and ordered a $1,500 fine. And in cause number CR 2256, you appeared on the charge of burglary of a habitation on that same date. And the court also followed the plea agreement in your case, deferred a finding of guilt, and placed you on community supervision for a period of 2 years and did not assess a fine. In cause number CR 2255, it appears that the state has alleged 11 separate counts. And in CR 2256, the state has alleged what appears to be 9 separate counts of violations. Mr. Wooten, have you had enough time to discuss both of these motions with your attorney, Mr. Schmidt?
Yes, sir.
And are you pleased with Mr. Schmidt's representation of you?
Yes, sir.
And do you understand everything that you've read and signed that's been a part of your plea agreement?
Yes, sir.
Mr. Schmidt, did your client waive the formal reading of both of these motions?
We do, Judge.
And does he intend to plead true to all counts in each?
Yes, sir.
All right, then, Mr. Wooten, well, let me ask Mr. Schmidt, are you confident that Mr. Wooten understands the plea, that he's entering into it intentionally, knowingly, and voluntarily, and that he is confident in doing so?
Yes, sir. I am.
All right, Mr. Wooten, then, as to cause number CR 2255, the state's motion to adjudicate your guilt, how do you plead to counts 1 through 11? Are those counts true or not true?
True.
And with regards to cause number CR 2256, on the charge of burglary of habitation, are the counts in 1 through 9 true or not true?
True.
And Mr. Wooten, has anybody threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
All right, then the court will accept the defendant's pleas of true to each count as alleged in each motion respectively. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of true in each case?
No, sir.
All right, then court admits both into evidence respectively and takes judicial notice of the defendant's judicial confessions of pleas of truth. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then based on the evidence before the court finds that Zachary Taylor Wooten has violated the terms and conditions of his community supervision. In each case, the court hereby adjudicates his guilt. In cause number CR 2255, the court convicts Mr. Wooten of assault of a family or household member by impeding breath or circulation, a third-degree felony, revokes his community supervision, assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division pursuant to the plea agreement. Court also takes under consideration in section 1245 of the Texas Penal Code, a violation of bond or protective order times 3 separate counts, all unfiled as reflected in the plea agreement. Court orders him to pay the balance of his financial obligations, including fine and reimbursement fees. And the court awards him 113 days credit towards his sentence for the time that he has spent in jail on that cause. And cause number CR 2256, the court follows the plea agreement and based on the evidence finds that he's violated the terms and conditions of his community supervision. The court adjudicates his guilt and convicts him of burglary of a habitation intending other felony. Court revokes his community supervision, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice, ordering him also to pay the balance of his financial obligations, including reimbursement fees. and court costs, and the court will order that each one of these sentences run concurrent to one another. And the court also awards him 113 days credit towards his sentence and this cost for time that he's already spent in jail. Mr. Wooten, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Go ahead, you, sir. Is
That's all I have, Judge.
that all you have?
Yes, sir. Thank you, Sam.
Good to see you. Who's next, Mr. Raymond?
Mr. Mulder's ready on, Carl Caver.
Good afternoon, Mr. Mulder.
Are you Judge?
Doing well. How are you?
I'm all right.
This is cause number CR 22-89, State of Texas versus Carl Claude Caver. Mr. Caver, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, sir. You can lower your hand. All right, Mr. Caver, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you, I'm sorry, go ahead.
On the 22-00089, we've had an updated judgment for 15 instead of 16. Other than that, everything's
15, okay.
yes, sir.
Any other changes?
No, sir.
Is the credit time still accurate, 702 days?
Yes, sir.
Okay, good, very well. Mr. Caver, you're represented by your attorney, Mr. Christopher Mulder. Are you pleased with Mr. Mulder's representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Sir.
And do you understand everything that you've read and signed in your plea agreement?
Yes, sir.
You have any questions before we go further?
No, sir.
Mr. Mulder, do you believe Mr. Caver to be competent?
Yes, sir, he is.
And do you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
Yes, sir, I do believe so.
All right, Mr. Caver, you are charged with a second-degree felony offense of bail jumping and failure to appear on a felony. A second-degree felony does have a range of punishment of not less than 2 years in prison or more than 20 years in prison and carries an optional fine not to exceed $10,000. I also believe that there's an enhancement paragraph contained in your indictment. Let's see, I've not been provided that, Mr. Hartwell. Can you provide that?
Yes, Your Honor. And Your Honor, would you like me to share the screen now or in a?
Yes, go ahead. Go ahead and share, please. All right, can you go ahead and make that larger? Just fill the screen with it. Thank you, that'll work. All right, Mr. Caver, go ahead and scroll down to the bottom. All right, Mr. Caver, down here in the indictment in your case, the state has alleged enhancement paragraphs increasing the potential punishment range that you would face. And it appears that the state is abandoning enhancement paragraph 2. And so I'd have to ask you, how do you plead to enhancement paragraph 1? Is that enhancement paragraph allegation true or not true?
Yes, yes, sir.
That's true?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead true to that?
No, sir.
And with regards to the bail jumping, how do you plead to bail jumping and failure to appear? Guilty or not guilty?
Guilty.
And you're pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, thank you, Mr. Hartwell. You can take that off the screen. All right, Mr. Caver, I see that upon your plea of guilt, that the state's recommending that your punishment be assessed at 15 years confinement in the Texas Department of Criminal Justice with a $1,000 fine, with your sentence running concurrent with cause number CR 23137. And let's see, do I have 137 in front of me, or is that a separate cause? Let's see. And in cause number CR 23137, you are charged with a second-degree felony offense of unlawful possession of firearm by a felon. And that carries the same range of punishment, not less than 2 years or more than 20 years confinement in prison, and a fine not to exceed $10,000. And I see that your plea agreement in that case is that upon your plea of guilty, the state's recommending the court assess punishment at 10 years confinement in prison with a dismissal in consideration, a theft of firearm, a weapon forfeiture, with your time running concurrent in the other case. So, Mr. Caver, how do you plead to unlawful possession of firearm by felon? Guilty or not guilty?
Guilty.
And how do you plead to the enhancement paragraph in cause number CR 23137? Is that enhancement paragraph true or not true?
Yes, sir. True.
True. And has anybody threatened, forced, or pressured you to plead true?
No, sir.
All right. Mr. Caver, I'm sorry, Mr. Mulder, you believe Mr. Caver to be competent today?
Yes, sir, I did.
And his jail time in his plea agreement on the unlawful possession of firearm by felon is different. It's 384 days. Is that correct?
That's correct.
All right, Mr. Caver is aware of that?
Yes, sir. We know that there's different amounts on the two cases.
Okay. All right, then based on the defendant's plea of guilty, the court hereby accepts his plea of guilty in each case respectively. The court also accepts his pleas of true in each case respectively as to enhancement paragraph number 1. Mr. Mulder, any objection to the stipulation of evidence supporting the pleas in each one of these cases?
No, sir, not in either case.
All right, then stipulation of evidence is admitted in each case respectively, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
All right, then based on the evidence in cause number CR 22-89, the court finds Mr. Claude Caver guilty of bail jumping and failure to appear, assesses his sentence pursuant to the plea agreement at 15 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $1,000 fine, orders this sentence to run concurrent with cause number CR 23137. The court awards him 702 days credit towards his sentence for the time that he has already spent in jail on that cause. In cause number CR 23137, the court hereby convicts Claude Caver of the second-degree felony offense of unlawful possession of firearm by a felon, assesses his punishment pursuant to the plea agreement at 10 years confinement in the Texas Department of Criminal Justice. The court orders court costs of $290 in each case respectively, orders $70 reimbursement in the firearm case, $65 reimbursement in the bail jumping case. And the court does take into consideration under section 1245, theft of firearm in unfiled DA 2023-1032, orders the weapon seized in that matter to be forfeited pursuant to the plea agreement in this case. And the court does order his sentence to run concurrent with cause number CR 2289. And the court awards Mr. Caver 384 days credit towards his sentence for the time that he spent in jail on this case. Mr. Caver, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted. Thank you, Mr. Mulder.
Thank you, Judge. May I have excuses?
Yes, sir. Good to see you.
Thank you.
Ms. Abraham, do we have anyone else ready?
Let me ask Mr. Manning.
Okay.
Just a- Can we take a recess for about 10 minutes?
Court's in recess for 10 minutes.
Thank you, sir. Your Honor,
Yes.
we're ready. It's okay if I.
No,
We just don't have papers on it.
no, he's going to TDC for 2 years. What?
All right, Mr. Manning, who are you ready on?
Judge, we are ready on, let's start with Mr. Huddleston.
All right, Michael Ray Huddleston, CR 23-136, CR 23-234, CR 23-235. Mr. Huddleston, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. You can lower your hand. Let me just look through your paperwork real quick.
And Judge, as you're looking, I don't know, I don't see it on the judgment itself, but attached to my paperwork is a motion to dismiss on CR 23-234, as well as a rejection or disposition in unfiled case number 20, DA 2023-0857. Do you have the paperwork as well?
Yes, sir, I do.
Perfect. Thank you, Judge.
All right, Mr. Huddleston. Let's go over your paperwork here. First, let me ask you. You are a United States citizen who reads, writes, and speaks English, correct?
Yes, Your Honor.
And, Mr. Huddleston, have you ever been diagnosed with a mental condition?
No, Your Honor.
In these cases, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your lawyer and the work he's done for you?
I am.
Is there anything about your plea agreement today that you do not understand?
No, sir.
Do you have any questions before we go further?
No, sir.
Mr. Manning, do you believe Mr. Huddleston to be competent, and if so, that he's entering into this plea intentionally, knowingly, and voluntarily after understanding his rights?
Yes, Judge, and I would like to add a slight amendment to Mr. Huddleston's statement earlier. He is on medication for a couple different things, and he is currently taking that medication. Through my interactions, he appears to understand what's going on, and I've had multiple opportunities to discuss this case with him in the past, and I believe he is entering into this agreement intentionally, knowingly, and voluntarily.
Thank you, sir. All right, Mr. Huddleston, in cause number CR 23-136, you appeared before the court back on July 25th of 2023 on the charge of violation of a bond or protective order 2 or more times within 12 months, which was a 3rd-degree felony. The court heard the evidence that day and found that you had reached a plea agreement with the state of Texas, and the state recommended that the court not convict you, but that the court defer a finding of guilt and place you on community supervision for 8 years. The court followed the state's recommendation in your plea agreement, and the court also assessed a $1,500 fine. During your period of community supervision, the state filed 2 motions to adjudicate. The second amended motion to adjudicate was filed on January 30th, 2024. And in that motion, that second motion to adjudicate, the state of Texas alleged that you had violated your community supervision in 7 separate counts. Mr. Manning, does your client waive the reading of the second amended motion to adjudicate?
He does, Judge.
And does he intend to plead true to all 7 counts?
Yes, Judge.
All right, and then Mr. Huddleston, in cause number CR 23-235, you were indicted on a 3rd-degree felony offense of stalking, which carries a range of punishment of not less than 2 years or more than 10 years, and a possible fine not to exceed $10,000. I see that there are plea agreements or recommendations from the state in your case, In your probation case, in which you are on for violation of a bond or protective order, upon your plea of true, the state appears to agree that your guilt be adjudicated, that your community supervision be revoked, and they're asking the court to assess your punishment at 7 years confinement in prison and ordering you to pay the balance of your fines, court costs. In addition, you would receive 222 days credit towards your sentence in that cause. In the newer cause, CR 23-235, on the charge of stalking, the state's recommending, upon hearing the evidence, that you be convicted, that you be sentenced to 7 years confinement in prison, also with court costs and reimbursement fees, and receiving 146 days credit time for towards your sentence for the period you've already been in jail on that cause. So, Mr. Huddleston, is that your understanding of the plea agreement in each case?
It is,
All right, that's what you're asking the court to approve today?
yes.
All right. On the probation case, violation of bond, protective order 2 or more times within 12 months, how do you plead to counts 1 through 7? Are those counts true or not true?
True.
And you're telling me that each one of those counts are true because what is alleged is in fact true. You're not just pleading true to get a plea agreement. Is that correct?
Yes, Your Honor.
Okay. And in regards to the stalking case, how do you plead to stalking? Guilty or not guilty?
Guilty.
And are you pleading guilty to that crime because you too are guilty of committing that crime?
Yes, Your Honor.
And has anybody threatened, forced, or pressured you to plead guilty or plead true in either of these cases?
No, Your Honor.
All right, the court will accept the defendant's plea of true and cause number CR 23-136 to each count as alleged. Court also accepts the defendant's plea of guilt as to the crime of stalking. Mr. Manning, any objection to the admission of the stipulation of evidence and the defendant's waiver of rights and plea of truth?
No objection.
All right, both of those are admitted into the cases respectively, and the court takes judicial notice of the defendant's judicial confession, plea of true, and plea of guilt. Anything further from the state?
Your Honor, just that in cause number CR 23-235, victim impact statement has been provided to the court and mandatory protective order has been filed.
And Judge, I don't believe we received a copy of the protective order for me to go over with my client.
Okay. So I guess we'll need to set that for a hearing. All right, we'll take up that in a moment. Anything further from the defense?
Nothing from defense, Judge.
All right, then based on the evidence in this case, each of these cases, cause number CR 23-136, court finds based on the evidence that Mr. Huddleston, the court accepting his pleas of true finds the plea of true in each of the alleged violations, finds that based on his plea of true and the court's acceptance of the same, that he has violated the terms and conditions of his community supervision. The court follows the plea agreement today, adjudicates his guilt for violation of a bond or protective order 2 or more times within 12 months. The court revokes his community supervision, assesses punishment at 7 years confinement in the Texas Department of Criminal Justice, orders Mr. Huddleston to pay the remainder of his fines and court costs, and orders that he receive 222 days credit towards his sentence for the time that he has spent in jail on that cause. In cause number CR 23-235, the court, based on the evidence, finds that there is sufficient evidence to convict Michael Ray Huddleston Jr. of stalking. The court follows the plea agreement, assesses punishment at 7 years confinement in the Texas Department of Criminal Justice, orders that he pay court costs of $290 and reimbursement fees of $70. And the court orders that he is awarded 146 days credit towards his sentence for the time that he's already spent in jail on that case as well. Court finds in cause number CR 23-234, the state has filed a motion to dismiss. The court hereby grants that motion to dismiss. And the court notes for the record that unfiled cause, DA cause number DA 2023-857 regarding an unfiled violation of bond or protective order from March 18th of 2023 was rejected due to the defendant's plea in the cases at bar. So the court's going to note that for the record. All right, Mr. Huddleston, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Before we fingerprint and adjourn, the state has filed a protective order. Is that something that's agreed? Just you've not had time to go over, Mr. Manning, or is this something that's not part of the agreement in these cases?
Judge, it was never agreed, nor was it discussed. I understand it is, or maybe mandatory. However, I do need to have the opportunity to go over that with my client, discuss what the implications of that are, and explain to him how that affects his life once he gets out. I would request a copy of that to be sent over, and if I'm able to get an agreement, then I don't mind forwarding that to the court. Otherwise, we will need to have a hearing on that.
Okay, all right, then I'll leave the setting of that until after you had an opportunity to review it and consult with Mr. Huddleston. And just notify the court if the hearing is going to need to be set.
Yes, Judge.
All right, for the record, the court has reviewed the victim impact statement, and the court is signing the victim impact statement tracking form, and I'll return that to the state of Texas. All right, Mr. Huddleston, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted with the deputy. Good luck to you, sir.
Thank you.
You're welcome.
So other than my kid, I couldn't be covered by it. How the hell are we gonna raise a kid? I'll finish it before it's done.
All right, Mr. Manning, who are you ready on now?
Judge, we're ready on Mr. Nathaniel Dean Whitley.
All right, this is cause number CR 1934, State versus Nathaniel Dean Whitley. Mr. Whitley, sir, you'll raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? I didn't hear you, but I saw your lips move. Can you just say it a little louder?
I do.
Thank you, sir. Okay, you can lower your hand. All right, Mr. Whitley.
And Judge, the paperwork you have has since been amended and corrected. And if you'd like, I can point out those.
Yes, sir, please.
On the front page of the judgment, the total jail time credit was determined to be 323 days credit. Mr. Whitley was housed outside of Van Zandt County for the majority of the time, if not all the time that he spent on this case. He was housed in both TDC, Henderson County, as well as Kaufman County. And we've done our best to track those incarcerations and when the warrants were applicable and when they were not. My client has agreed to this number. However, I have explained to my client that if he is able to provide any further documentation or find that this is incorrect, that he can speak to TDC and petition them to correct those judgments. Additionally, Judge, on the next page, under the particular conditions violated, the list includes B, D, M-2 O and V. State is abandoning count 5, which is condition A. That is a still pending offense in Kaufman County. Other than those two corrections, I believe the paperwork is correct.
All right, the state, you're abandoning count 5.
Yes, Your Honor.
All right. All right, thank you, Mr. Manning. All right, Mr. Whitley, you appeared before the court on August 26, 2021. I believe at that time you had received a motion to adjudicate. You were previously on deferred, and based on the state filing a motion to adjudicate your guilt, you appeared on August 26, 2021. Based on the evidence at that time, you were then convicted of the offense of injury to a child, elderly, or disabled with intent to commit bodily injury, a third-degree felony. Punishment that day was assessed pursuant to a plea agreement that you reached with the state at 7 years confinement in prison and a $2,000 fine. The court then suspended that sentence and placed you on probation for 2 years. And during that probationary period, the state filed an amended motion to revoke. And in that count, in that alleged multiple counts, they alleged counts 1, 2, 3, 4, 5, and 6. And the court finding that the state has abandoned count 5. Have you had enough time to review that with your attorney, Mr. Manning?
Yes, sir, I have.
And are you satisfied with Mr. Manning and the work he's done for you as your lawyer?
Yes, sir, I am.
All right, and Mr. Manning, do you believe Mr. Whitley to be competent today
He is, Judge.
and that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
He is. We have discussed this case both over the phone as well as in person, both here and in Kaufman County. I've gone over his options, and I believe that these represent an intentional, knowing, and involuntary waiver of a hearing and acceptance of a plea in this deal.
And does your client waive the formal reading of the state's amended motion to revoke?
He does.
Right. All right, Mr. Whitley, understanding the plea agreement today, which is upon your plea of true to counts 1, 2, 3, 4, and 6, I believe. The state is recommending that your community supervision be revoked and your punishment be assessed at 2 years confinement in prison, with you being ordered to pay the remainder of your fines, court costs, and receiving 323 days credit towards your sentence. Is that your agreement with the state?
Yes, sir.
All right, then, Mr. Whitley, understanding the plea agreement, I would ask you at this time, how do you plead to counts 1, 2, 3, 4, and 6? Are those counts true or not true?
True.
You're telling me that those specific counts are true because what is alleged is in fact true. You're not just saying that to get a plea agreement. Is that correct?
That's correct.
All right, then the court will accept the defendant's plea of true to counts 1, 2, 3, 4, and 6. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No, Judge.
That is admitted, and the court does take judicial notice of the defendant's judicial confession in his pleas of truth. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Nothing from defense, Judge.
All right, then based on the evidence, the court finds the allegations to be true. The court hereby follows the plea agreement and recommendation of the state. The court adjudicates, the court revokes the community supervision of Nathaniel Dean Whitley, assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 323 days credit towards his sentence for the time that he spent in jail on this case. Mr. Whitley, you're hereby remanded to the custody of the sheriff so to carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. You ready on anyone else, Mr. Mann?
Yes, Judge, I'm ready on my resets.
All right, who are those?
Judge, if you want us, we can start with Mr. Hersberger.
All right, this is cause number CR 24-69, State versus Jacob Thomas Hersberger for arraignments. Go ahead, Mr.
And Judge, unfortunately, I was unable to pull up the indictments in each and every one of these cases. So if we could have those displayed. That's 220. So. Two. Winchester, three. Judge, his name is spelled correctly. He understands the charge against him as well as the range of punishment. Pleads not guilty this time. We request to be set on the pretrial docket.
All right, the court finds that Mr. Hersberger has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record, sets this matter for pretrial hearing. You want you, I got,
Judge, I can do June 13th on him. We've actually reviewed a majority of the discovery.
okay.
And if provided I can get some time with the state to negotiate, I think we'd be able to keep moving this case pretty quickly.
All right, court sets Mr. Hersberger for pretrial June 13th at 1:30. If Mr. Hersberger makes bail in this case, then the hearing will be at 9 a.m.
Thank you, Judge. Tomorrow or next Friday. Judge, next ready on Jean-Luc Hansen.
All right, cause number CR 24-73, State versus Jean-Luc James Hansen for arraignment. Do you need the indictment on this one as well?
Yes, please, Judge.
Stand by.
Judge, his name is spelled correctly. He understands the charge against him as well as the range of punishment and asks to be set on the pretrial docket.
All right, court finds that Mr. Hansen has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, sets this matter for pretrial hearing. you need something longer than 13th?
Yes, Judge, I anticipate filing a competency motion on Mr. Hansen.
All right, how about, let's set it to July 11th,
Yes, Judge.
July 11th at 1:30 for pretrial.
Just-
What do you want next?
Judge, ready on Mr. Garrett Joslin.
Garrett Lee Joslin, CR 24-86. For arraignment.
And Judge, I don't think we'll need to pull this one up. Judge, his name is spelled correctly. He understands the charge against him as well as the range of punishment. At this time, he's going to plead not guilty and request to be set on the pretrial docket. Judge, I don't believe I've had access to discovery on this one, so I'd request a little bit longer. The 7/11 date should work.
All right, court finds that Mr. Joslin has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record, sets this matter for pretrial July 11th at 1:30.
Thank you, Judge.
Who do you want next?
Judge, next ready on Mr. Parks, Joseph Parks.
Joseph Leon Parks, CR 22-192. Motion to adjudicate or revoke.
Judge, we're gonna, at this time, we need to set for a contested hearing.
I can set it, like state, let me know what you want, but I could set it 2 weeks on May 30th, or we can set it June 20th.
Judge, my understanding is the state's witness will not be available on the 30th. So while we would probably prefer that, I think it'd probably be a bit unfair to the state.
The state, is your witness going to be available on June 20th?
Your Honor, I'm pulling up that case now. Thank you.
Is this a case involving Miss Mewburn?
No, Judge, this is a case involving Ms. Matura, Officer Matura.
Yes, Your Honor, that is correct. We would need the later date.
Is she going to be available on June 20th?
Judge, my understanding from the probation office is she will be available on the 20th.
All right, court sets Mr. Parks for contested hearing June 20th at 1:30.
Hey, page reset.
Who's next?
Judge, I think the last one I have is Mr. Sprous, Michael Sprous.
We also have Amber Simpson.
I do have Amber Simpson. I like just a moment before I make an announcement on her, see if I can't get something figured out.
All right, cause number CR 23-17, State versus Michael Raymond Sprous for docket call. Good, Mr. Mayor.
Judge, I have met with Mr. Sprous, gone over the discovery. I've had multiple meetings regarding the state's offer. State made an offer for time on this case. I discussed options for lesser included offenses or some other type of resolution. But the state was firm in their offer for time. My client does not want to avail himself of that offer. However, he has indicated to me that he also does not want to go forward at trial at this point. And so, correct me if I'm wrong, he wishes to make a not ready announcement at this point in time. I explained to him that the court has set him for final docket call today, and that absent some compelling reason other than us unable to reach negotiations to a point that were satisfactory to him, that the court was most likely going to set us for jury selection. I've explained to him the pros and cons of jury selection and what we have. What I think are some defenses to the case. There is some exposure that I've discussed with him that he'd be looking at on this particular case.
So there's no reason for the not ready other than he hasn't received an offer that he's willing to accept.
Well, Judge, I have not gotten a rejection from him on the offer that's been made. I believe my client faces what many people call analysis paralysis. He's unable to take the information that he's been given and come up with a solution or an answer for me to convey to the court at this point in time.
All right. Court did, all of the things that you have stated, Mr. Manning, are correct. Your summarization of what the court would do is correct. And so the court not hearing that there's any announcement by the defense of requesting a jury trial or requesting a plea agreement, and not hearing the state wanting to tender a motion to dismiss, the court's left with setting this for jury trial. We'll set jury trial beginning Monday, June 3rd. Obviously, Mr. Sprous will not be tried on Monday, June 3rd. However, he will be on the court's rolling trial docket until his case is reached for trial. And we'll send you new notices each time the jury selection date changes.
Yes, Judge. Sit down.
All right, you said you need some more time with Ms. Simpson.
Judge, just a couple minutes.
That's fine, no problem. We'll stand in recess.
Your Honor.
Your coordinator.
Did you see my text?
I'm seeing it right now.
Okay, I'll see you momentarily. And are you going to be in the courtroom or in your office, Miss Burns would like to know?
I will be in my office.
So we have this one last one and then that's it.
Yes, ma'am. There is Deputy Banda in the flesh. Well, how did things go? This way or this way? Went this way?
Yeah.
Well, for one.
For which one?
You know what I'm talking about.
Yeah.
Oh, so we went from here to here?
Yeah.
What does that mean?
Thought it's good.
You thought it was good? Excellent. I'm glad to hear that.
Did you
Good
see
to-
the game last night?
The Mavs game?
The Rangers?
Oh, no, no. Were you on the Jumbotron or something?
I was trying to be on there.
No, I was busy watching the Maverick game.
We went 4-0.
Pretty good. Pretty good.
That it?
They're working on that one.
We'll be back.
Judge, we're ready.
All right, Ms. Simpson, if you'll come forward. This is cause number CR 14369, State versus Amber Michelle Simpson. Motion to adjudicate. Go ahead, Mr. Manning.
Judge, I've spoken to the probation department about a possible solution for Miss Simpson's case. And I am attempting to get a hold of, speak with Miss Curry. I know she's got a pretty busy schedule this afternoon, and so if the court will indulge us, we can set her at the earliest possible date. And then if we are able to move forward with the proposed solution to resolve her case, I believe that would involve a motion to withdraw and extend with amended conditions. We could assign that without her having to be brought before the court in the future.
All right, let's just set her on the contested docket, not anticipating that it'll be contested, but that's the next one, May 30th.
Thank you, Judge.
If y'all work out something before now and then the state can always send over a motion to withdraw and amend, and court can do that without a hearing.
Thank you, Judge. Sorry. Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Manning.
Thank you, Judge.
All right, Mr. Hartwell, I think that does conclude the court's criminal docket for this afternoon. Actually, Mr. Manning. Oh, hang on, yeah.
Yes, Judge.
One more, Justin Guyton, CR 2454. I have him verified still in the Anderson County Jail. I know that he's set for trial August 5th in Anderson County. Do you know anything more about that, Mr. Manning?
That's news to me, Judge.
All right. State, do you know anything more about that?
This is the first time I've heard about it, Your Honor. I'm sorry.
All right, so I'm sure Ms. Taberhan's probably just pulling that offline, but let's reset Mr. Guyton for arraignment on August 13th. No, I'm sorry, August 15th. It's a Thursday. I know that's setting it out, but we'll let him conclude his business in Anderson. If for some reason the state needs him before they take him to trial, then file a request for a bench warrant.
Thank you, Your Honor.
All right, thank you, Mr. Manning. Sorry about that. That does now conclude the court's afternoon docket.
Judge, was that August 18th or 15th?
That's going to be August. Did I say 18th? If I did, I meant to say 15th.
15th, okay.
Yeah, August 15th at 1:30 for Mr. Guyton.
Yes, Judge.
What is
August 15th.
Judge, will be excused.
Yes, you're excused. Let's see if I can do this again. I believe that concludes the court's criminal docket for this afternoon, Thursday, May 16th, 2024, the year of our Lord. And we are hereby adjourned. Thank you, gentlemen.
Thank you.